So on this, as he is always as he is always so brilliant in deconstructing this stuff, our very good friend Andy McCarthy, he's got a great piece up at National Review about this. I have tweeted it out as well, and I'll make sure that we have it in the video for his our discussion here. You know him, best-selling author, contributing editor at National Review, and also former chief assistant U.S. attorney, and he's also on Fox News. You can see him there. Andy, as always, so appreciate your time with us today. And you are also questioning and disagreeing with the legality that some are saying that Biden has to be able to implement something like this through employers. What is your take on this?
Dana, I think this has now gotten to the point where it's more performative than anything else, in the sense that I think they know what they're trying to do is illegal. And in fact, if Biden issued this as an executive order, I think he knows it would be shot down instantly. So they're trying to do it through a maze of bureaucratic regulation through OSHA. And even on that score, they're not doing it properly, because they're trying to, the ploy they're going by is this emergency authorization that they want to do. And the purpose of that is to avoid the commentary period that's required under the Emergency or the Administrative Procedures Act. The OSHA hasn't tried to do this since 1983, when the court shot it down over an asbestos regulation they wanted to do. So even on its own terms, they're trying to get around the administrative bars that shouldn't allow this. But the basic thing is, this is a state law issue. Vaccines and this kind of medical treatment traditionally in the United States has always been a matter of state law. And it's only been a couple of weeks since the eviction moratorium case where the Supreme Court, even though I think they ducked the basic question, which is under the Commerce Clause, should the federal government be allowed to do this at all? What they say is, assuming Congress has the authority to do this, if the federal government wants to intrude on an area that's traditional state law, Congress has to have spoken precisely and unambiguously to authorize it. And I think what you're going to see here is the same thing we saw a couple of weeks ago with the eviction moratorium, which is they haven't.
And we're talking with Andy McCarthy, and that's, from what I understand, my non-trained lawyerly perspective, the courts really don't respond favorably to kind of trying to run out the clock by just giving yourself a head start by through having the snake through all of the procedures and through the court system, et cetera, because that seems like what Biden's relying on here. Like they know that it's not, as you were saying, that it's not something that they can legally do. It's not constitutional. And so they're going to do it anyway and just use the time that it's going to take to worm its way through the court system before it's struck down. They'll at least have enough headway to do that. I don't think that's never been looked upon favorably by the courts, has it?
Well, look, I think the first thing is, if your mind isn't wired to work this way, good for you. That's good for your mental health. So I salute you for that. But, I think the moratorium case should have been 9-0. It should have been like the slam dunk of all time. And it was 6-3. And the three progressive judges on the court, Breyer, Sotomayor, and Kagan, wanted to do exactly what you just described, which is use the procedures of the justice system in a punitive way when there wasn't authority. The bottom line, the merits of the case, there wasn't authority for the federal government to delay rental payments. But they figured if they said, well, we're not going to interrupt here on a application for an injunction. We haven't had a full briefing yet. We haven't had a trial. Why don't we go back and do all that? If you did that, it would take months, and the landlords, of course, would continue not to be paid, and they'd be being punished. That's exactly the kind of thing that you would think would offend any good judge. The idea that you're using the processes of the court, which are deliberate because we want courts to come out to right results, and instead of using them for the reason they're there, to improve the justice system, you actually use them to penalize one side of the litigation, which is exactly what happens here. And I hate to get political on it. Well, I don't hate it that much, but I mean, to be clear, people always say, conservative judges impose conservative preferences and liberal judges impose liberal preference. That's not how it works. What it means to be a conservative judge is to follow the law, even if your policy preference is not what you get at the end of the rainbow. And what it means to be a progressive judge is to impose the progressive outcome however you need to impose it. And if that means using the justice system's regular procedures in a punitive way, you do it that way. If it means that you should win on the merits, you suddenly become a strict constructionist. But you do whatever you need to do to get the outcome. So, I wish it were true. I wish I could stand here and say, judges will be really offended by the administration's behavior here because they're doing things that they know are illegal, but they figure it'll get slow walk through the court system and they'll be able to change the facts on the ground and they'll get the outcome they want. I wish every judge would be offended by that, because it shouldn't be about the outcome. It should be about using the court's procedures in a punitive and cynical way. But unfortunately, I think a lot of progressive judges who want to see the same kind of policy results that Biden does are not as offended as they ought to be about this stuff.
We're talking to our friend Andy McCarthy, former chief assistant U.S. attorney there, and Andy too. You've seen this all the discussion, and I love whenever things happen like this on social media. The expertise of all of the users of Twitter changes to go along with whatever the news cycle is. So today, Andy, as you've seen, I'm sure that you feel so much better knowing that you have so many other legal scholars for company. But a lot of people have been talking about Jacobson v. Massachusetts. Now, I kind of remembered this from college on something on public policy, and I remember it came up, I think, at like the beginning of the pandemic when they were trying to shut down churches, and there was a court battle over that. But from what I understand, and correct me if I'm wrong on this, to use Jacobson versus Massachusetts, and that was the case for those listening of Amanda did want to get the smallpox vaccine and was fighting that in the state of Massachusetts, and it was determined that he had to pay a $5 fine if he refused it, and that's like $150 today, and you could opt out, but you had to pay the fine. And to use that as justification, a legal defense of Biden's move, because that was a state law, not a federal issue, and it was a law. It wasn't an executive order. So I'm not quite sure, and I've seen a lot of Democrats use that today and even yesterday. What is your response on that as it relates to justifying Biden's mandate?
Yeah, I think that's not only right, Dana, but that case was decided in 1905 before the Supreme Court developed what is now the test that it uses when there is a claim that some kind of federal action or government action is infringing on somebody's rights. So right. Now when a case like this comes up, what the court will say is this a fundamental right? Because if it's a fundamental right, then we're going to require the government to show that it has a compelling reason to regulate, and that the regulation it's chosen is the least restrictive alternative that it could come up with. And if it's not a fundamental right, then we say the government has to show an important interest, and they only have to show that the regulation that they've put out is rationally related to what the interest is. And what that, in a nutshell, what that means is if they say this is strict scrutiny, which is the higher level, sometimes individual liberty wins. And when they say rational relation, always the government wins. And that's pretty much how it comes down. But that test did not get developed until long after Jacobson in 1905. And a number of judges who've looked at this stuff, including, I was trying to remember who it was on the Supreme Court. I think it was Justice Gorsuch, but I didn't have time before we got on to go back and look at this. But I think in the
yeah, you're right.
In the Cuomo case, where they were looking at New York's attempt to regulate how many people could show up at or attend religious services. One of the things, I think it was Justice Gorsuch who floated out, was that we ought to take another look at this whole Jacobson thing, because it was so different, and it was a product of such a different time and place than what we're talking about now. So I think you're going to get, when this eventually gets hashed out in front of the Supreme Court, which could be soon, but it could be, a year from now, who knows? I think there's a number of justices on the court who would be willing to ask whether Jacobson is being stretched way beyond what it meant when it was first issued.
Yeah, we're talking with our friend Andy McCarthy, and I remember, and I had read something. I was trying to remember where I was reading this, where with Jacobson, this was it was about the state law, a very small fine. You could opt out, but this, from what I understand, it wasn't pushed as a condition of employment, which is seemingly what this vaccine mandate presented by Biden is being pushed as now.
Yeah, no, that's right. And as you pointed out, it was a $5 fine and you could just get out of it. What people ought to be upset about, I think, is that the people who are now running our government have taken what used to be $5 and turned it into $150.
Yes.
So if they can't manage the currency, which is like their job, why do we want them doing everything else?
Yeah, that's a great point. That's a great point. Last question for you, talking to our friend Andy McCarthy. So you think that this actually could go back before the Supreme Court? This whole fight over this mandate, correct?
Yeah, but it may take some time. I mean, I don't know that it'll get up there as fast as the eviction moratorium did. I would like to think it would, but the eviction moratorium got up there quickly because the Supreme Court said, Kavanaugh basically came out and said, you need clear authorization from Congress. The Biden White House came out and said, the Supreme Court has said we need clear authorization from Congress. And the day after they did that, Biden said, I'm going to do it anyway.
Yeah.
And, I think then the realtors ran into court, and the court, to its credit, could have slow walked it. And instead, the district judge decided right away. The D.C. Circuit decided right away so it could get to the Supreme Court quickly. I don't know if we're going to see that here.
Boy, I hope so. I hope it's fast tracked that way. Andy McCarthy, our friend, we always appreciate you joining us on the show, giving us your expertise, sharing your expertise with us on this. Have a great weekend. Thank you so much, Andy.
Thanks, Danny. You too.
Of course.